what is playing out in Nigerian judiciary of late, is really disconcerting and worrisome. It will appear that the Nigerian judiciary has moved from unsavory trajectory to what I may call unguarded predilection. In their affairs, we have moved from the issues of maintenance of status quo to the court, proceeding with a matter when there was a pending order of a superior court of appeal mandating the court not to proceed. Now to a court opening a matter when the court is functions official. Directly to answer your question, that matter shouldn't have been entertained in the first instance, because the law is very clear that by virtue of sections 77 and 79 of the Electoral Act 2026, read in conjunction with sections 221 and 222 of the Nigerian Constitution, no association has the right or the power to claim exclusive right, ever a party name, a party symbol, a party logo that was not registered with Inec. So insofar as the logo in issue was not registered by Inec, nobody can claim that that logo belongs to it. And to that extent, the Federal High Court sitting at Lokoja, if the court advised its mind to the sections I mentioned, section 77 and 79 of the Electoral Act 2026 and section 221 and 222, the court would have come to the conclusion that the court shouldn't have entertained that matter in the first instance, because there was no proper plaintiff with the requisite local standing, to activate the court's jurisdiction. But for reasons best known to the court has interest of fair hearing. The question is, whose fair hearing? Because neither the person who commends that action on behalf of PMP nor PMP had the powers, had the locus, had the right to go to court over a logo that was not registered by Inec. So if they do not have the right over the logo, how can the court now entertain a suit, an application purporting to accord them the right to be heard over what they do not have? So I will say that the court erred very grievously to have entertained the matter in the first instance. The court erred, in the second degree, to have purported to have overturned its initial judgment that was delivered on merit, and the court even was in the session by not addressing its mind to the clear and mandatory provisions of sections 77 and 79 of the Electoral Act 2026 and 221 and 222 of the Nigerian Constitution. And to that extent, I will say that that suit shouldn't have been entertained in the first instance, in the absence of any legal right by the plaintiff in that matter and the party PMP, which he purported to have sued on behalf. That plaintiff was very much aware that PMP, is not a juristic person. That person is very much aware that PMP couldn't have sued. That's why the person now sued, purporting to be a representative of a PMP. So if PMP does not enjoy legal status, certainly the person who claimed to have represented it could not also enjoy legal status. So that case has caused unnecessary and distracting problems in the polity. So I want to advise all involved, especially the NDC, to, as a matter of urgency, I'm happy they did that, to approach the appellate court and ensure that order is set aside. But in the interim, Inec is headed by Professor of Law, whom I'm very much aware. He's very much, he's much the Professor of Law, who is the chairman of Inec, should not bother so much with what I may call the antics of the judiciary. The Inec chairman, I'm not advocating, total disregard or disrespect to judicial proceedings, should be guided by the application filed by ADC, and therefore not pay heed, and therefore not obey, and therefore disregard the purported judgment of the purported ruling of the Federal High Court sitting in Lokoja, because that judgment, to all intents and purposes, is an unmitigated nullity. Like I said before, the plaintiff, the PMP, had no exclusive right to have commended that suit, and to that extent, they have no local standing. and they have no legal standing, the court has no jurisdiction that entertain the matter. Because in the absence of clear registration by Inec, as stipulated in sections 74, 75, 76, 77, 79, 79 of the Electoral Act, nobody can claim to have any exclusive right of any name, any logo, or any symbol. And if the person hasn't such a right, the person cannot go to court to enforce a right the person doesn't have. So what they should now do is to go through the rudiments, to go through the judicial process and make sure that the order is appropriately set aside. But in the interim, INEC is advised to be guided by the processes filed by NDC and served on INEC, because let's say the clear provisions of the Constitution and the Electoral Act, that judgment is a complete and unmitigated nullity.